In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Right answers in the comments. Participants in the cryptocurrency market have recently begun debating Ethereum Gate, which refers to the U.S. Securities and Exchange Commission, SEC, supposedly granting preferential treatment to the Ethereum Foundation. With XRP attorney John Deaton admitting that he has seen papers relating to the alleged wrongdoings, it is expected that these events are only the start of a lengthy investigation. The discussion around Ethereum Gate heated up when Steven Nareyoff, an early advisor at the Ethereum Foundation, said in a September 17, 2020, tweet that the foundation was concealing the true number of ETH purchasers during the cryptocurrency's 2014 initial coin offering, IQOO. CoinGate previously published XRP lawyer John Deaton's disclosure that he has seen some of their receipts that might reveal the truth regarding the ICO figures. While consenting to examine the data, the lawyer reportedly alluded to Ethereum when he said that he could not release the identities due to attorney-client privilege. This signifies that Nareyoff signed a contract with attorney Deaton. This might imply that Deaton will defend the former advisor in court if necessary. Another attorney, Fred Rispoli, underlined that the attorney-client privilege might have far-reaching consequences in the future. He cautioned that the collaboration might have far-reaching consequences with very big things to come. Does this imply that Nareyoff will sue the Ethereum Foundation over the framing of fraud charges? Attorney Deaton is well known for his belief that the U.S. Securities and Exchange Commission promoted Ethereum while making the Ripple project a scapegoat in its enforcement efforts. As a result, a prospective lawsuit on Nareyoff's behalf might be filed in the coming months. Blockchain, the groundbreaking technology behind cryptocurrencies, has prepared the way for a decentralized financial environment. The absence of a defined regulatory framework, on the other hand, has often been a subject of disagreement between blockchain enthusiasts and regulatory organizations. Recently, Ripple's chief legal officer, Stuart Alderoty, and XRP supporter, John E. Deaton, moved to social media to call out SEC chair Gary Gensler for his anti-crypto comments. Their claims came in response to Gensler's Bloomberg interview, in which he urged for the application of securities regulations to cryptocurrencies in order to avoid fraud and manipulation. The critique comes at an opportune moment, as the crypto sector, represented by companies like Ripple and Coinbase, has been aggressively pursuing regulatory clarification in the United States in order to stimulate innovation and investor protection. Alderoty criticized Gensler's approach, accusing him of disregarding court rulings and hurting the drive for regulatory certainty. Deaton, on the other hand, expressed similar worries, underlining the need of investor protection against the SEC's anti-crypto stance and hypocrisy. The argument goes beyond words. Deaton is a powerful voice in the crypto legal sphere, representing a sizable percentage of XRP holders. The issue sparked more discussion in the cryptocurrency community, with Steven Nareyoff, an early Ethereum consultant, remarking on the $19.02 trillion loss-of-use family wealth during the housing crisis, which occurred under regulated institutions. He hints at irony by doubting the efficacy of legislation in protecting individuals against fraud and manipulation. Furthermore, Deaton plans to interview Nareyoff on CryptoLoud about Ethereum's initial coin offering, ICO, and potential SEC manipulation. In addition, federal courts have labeled the SEC's statements in previous litigation as arbitrary and capricious, with Judge Netburn in the Ripple case labeling the SEC's conflicting views as disingenuous. The continuing legal and public debate shows the maze of regulatory uncertainty that has ensnared the cryptocurrency business. Despite these intense debates, the basic problem has not changed. The critical need for a fair and transparent regulatory framework that supports innovation while protecting investor interests in the quickly growing blockchain field. Empower Oversight Whistleblowers as Research, a rigorous watchdog organization, has spearheaded another incisive Freedom of Information Act, FOIA, endeavor in what could be described as a relentless pursuit for granular transparency regarding the Securities and Exchange Commission's (SIPU) prior actions regarding cryptocurrencies and Ripple. This strategy is geared on clarifying Jay Clayton's interactions with a pantheon of parties considered essential to the SEC's often controversial Bitcoin enforcement approaches. Clayton's tenure as the SEC's most powerful chair, which lasted from May 4, 2017 to December 23, 2020, included a number of landmark occurrences. At the forefront was Clayton's declaration of Bitcoin's non-security status, which was shared by other top figures about other. Bill Hyman delivered his notorious lecture in which he argued that ETH is decentralized and hence not a security. Hyman violated the advice of other authorities with the speech, as disclosed in the legal dispute between Ripple and the SEC. These allegations have a significant amplifying impact on the dynamics of these digital assets' worth. This upward trajectory, however, was hampered by the SEC's unexpected legal onslaught against Ripple, which questioned the XRP token status as a security. When paired with Clayton's later affiliation with One River Asset Management, a hedge fund with an exclusive portfolio emphasis on Bitcoin and Ether, this lawsuit fueled speculation. Among these swayings, Empower Oversight issued a firm statement. Empower Oversight has submitted a new Freedom of Information Act, FOIA, request seeking communications between Jay Clayton regarding the agency's ostensible misalignment in cryptocurrency enforcement stratagems. Empower Oversight tries to dramatically widen the nexus of persons possibly enmeshed inside Clayton's contact environment in the convoluted structure of this newly minted FOIA petition, aimed to Raymond Messina, the SEC's main FOIA custodian. The database, which includes names like Jasmine Burgess and John D'Agostino, seeks to identify any hidden conflicts of interest entwined within Mr. Clayton's SEC stewardship. The whole issue has not gone ignored by crypto stakeholders. When I first raised the huge conflicts of interests, I was called a conspiracy theorist by many in the industry. Renowned Proc-Sharp attorney John E. Deaton reminisced on X, previously Twitter. Empower Oversight found emails demonstrating Hyman violated 18 U.S.C. 208 many times with Clayton's full knowledge and implicit permission. Is Empower Oversight also a conspiracy theorist? Let's not forget, Clayton was the only commissioner to see and read the draft speech before it was delivered, Deaton said. Hyman did not transmit a copy of the letter to Hester Pierce. That's correct, crypto. Mom was not informed about the most important speech in crypto history. Ripple seems set to win a decisive victory in its legal fight with the U.S. Securities and Exchange Commission, SEC. As a result, the corporation just engaged a well-known lawyer to assist with that aim. James K. Fialon, a defense lawyer and former federal prosecutor, revealed on X, Twitter, that Rahul Mukhi would defend Ripple and its CEO Brad Garlinghouse in their current dispute with the SEC. Mukhi has extensive expertise in the sector, having worked as an assistant United States attorney from 2010 until 2016. He then joined the multinational legal firm Cleary Gottlieb Steen Hamilton LP Steen Hamilton LP as a counsel and partner. Mukhi has overseen key cases, including financial and tax fraud, public corruption, cybercrime, money laundering, and organized crime during the last decade. The SEC filed a complaint in December 2020, alleging Ripple of trading billions of dollars in XRP as securities without registering with the commission. The intense struggle progressed through many phases throughout the years as both entities fired bullets at one another. However, Ripple seems to have a significant edge since, in July, a U.S. court found that the majority of its XRP sales did not represent an offer of investment contract. In the continuing legal struggle between Ripple and the U.S. Securities and Exchange Commission, notable XRP supporter John Deaton recently shed light on possible conflicts of interest and regulatory capture that may have impacted the SEC's decision to sue Ripple. These claims are centered on Ethereum. The elaborate Eth-Gate tapestry displays a complicated network of links. The charges are complex and difficult to understand. Deaton condensed the most important elements in a recent tweet. Deaton draws attention to a series of occurrences involving former SEC chairman Jay Clayton and SEC staffer William Hinman. On March 26, 2018, Lowell Ness, a lawyer for A16s, reportedly handed Hyman a memo and a safe harbor form. ETH was clearly mentioned in the paper. Shortly after, Hyman proclaimed ETH to be a non-security, despite the fact that he was not formally retired and was still a prophet. Sharing partner with his law company, which was a member of the Enterprise Ethereum Alliance. Hyman's law firm was a member of the EE, and Hyman was not retired, but rather a profit-sharing partner with his law firm when he declared ETH a non-security 10 weeks later, Deaton writes. Furthermore, Deaton claims that Clayton's legal firm represents Joseph Lubin, ETH's co-founder, as well as Consensus, a prominent ETH holder and proponent. Another possible conflict is highlighted by Deaton, who says Clayton's firm also brokered the merger between Quorum and Consensus, using the Jeepman coin, a direct competitor to Ripple and XRP. Joe Grunfest's presence complicates things even further. Grunfest, according to Deaton, was an essential component of the aforementioned working group, and he had communications with Ethereum creators as early as 2014-2015. Deaton quotes Grunfest, saying, he said XRP should not be treated any differently than ETH. Grunfest suspected that the wholesale evacuation of Clayton, Hyman, Berger, and others was suspicious. He said there was no basis to file the complaint since XRP has been openly traded for 7 years, and that innocent people with no connection to Ripple would suffer the most. Regardless of the pleadings, Clayton decided to sue Ripple on his way out of the SEC. Clayton soon joined One River, which had already invested $1 billion on Bitcoin and Ethereum. In tying the story back to Hyman, Deaton says Hinman returned to his e-law firm $15 million richer after less than 3 years at the SEC, and then later became partners at A16s with the same people who helped put that list together, asking for the safe harbor for ETH. Furthermore, Deaton doubts Hyman's adherence to directions, alleging that his own SEC emails prove Hyman ignored that instruction and violated 18 U.S.C. 203 times by meeting them. Deaton's disclosures are noteworthy, implying improper actions and relationships inside the SECs at the time of Ripple's complaint filing. As of the time of publication, neither the SECs nor the parties involved had issued any formal remarks in response to Deaton's charges. With the second deadline for the U.S. Securities and Exchange Commission's spot Bitcoin ETF set for the third week of October 2023, the focus is now on other key events affecting the crypto market. This might come up again at the forthcoming hearing in the context of the XRP lawsuit judgment, which classified token sales to regular customers as not securities. The Bureau of Economic Analysis is scheduled to issue the August Personal Consumption Expenditures (PC) price index data on September 29, 2023. On September 29, 2023, Ripple will hold the proper party in New York City. It will be a communal celebration of legal freedom as a result of the recent partial success in the SEC litigation. While the event has no direct influence on XRP demand and supply, it may have an impact on market mood. Furthermore, it is likely that the corporation would make no major announcements during the event.